Be ready. Start. So far as allegations of alteration of Form 26, suppression of assets, or criminal antecedents, filing of false affidavit, and commission of corrupt practices under sections 123 and 125A of the RP Act, it is the stand of the respondent number 1 that such allegations are based on surmises and conjectures unsupported by material facts with no particulars of time, place, and persons involved, so also without the mandatory affidavit in Form 25 as prescribed under the proviso to Section 83 of the RP Act, read with Rule 94A of the Rules 1961. A ground has also been agitated by the respondent number 1 that allegations regarding non-disclosure or misreporting of election expenditure under sections 77 and 78 of the RP Act, non-publication of criminal antecedents, invalidity of nominations, as well as the throwaway votes are repetitive, speculative, and baseless. It has further been stated that the violations of sections 77 and 78 do not constitute a ground for setting aside an election under section 100 of the RP Act, as a separate mechanism has been provided under the RP Act, and the same cannot be a ground to challenge the election of the respondent number 1. Emphasizing the legal provisions, so also the settled position of law, Leonard Senior Counsel for the respondent number 1 submitted that Section 83 1A of the RP Act mandates that an election petition must contain a concise statement of material facts on which the petitioner relies. Omission of material facts renders the petition liable to be dismissed under Order 7 Rule 11A of CPC. Material facts are those facts which constitute the complete cause of action and would afford the basis for the allegations made. Thus, omission of a single material fact would lead to an incomplete cause of action and the plaint would become bad. Leonard Senior Counsel for the respondent number 1 further submitted that election petitions, being serious in nature, cannot be treated lightly or in a fanciful manner or used for vexatious purpose. Thus, an election petition lacking even a single material fact is liable to be summarily dismissed. Leonard Senior Counsel for the respondent number 1, relying on the judgment of the Supreme Court in Jyoti Basu and others versus Devi Ghoshal and others, reported in 1985, 1 SCC 691, submitted that the rights to vote, to be elected, and to challenge an election are purely statutory rights exercisable only in the manner prescribed under the RP Act 1951 and are subject to the statutory limitations therein. Therefore, an election petition filed in non-compliance with the provisions enshrined under the RP Act 1951, read with rules framed thereunder, is liable to be dismissed in limine.